Pushing back, the moral obligation of challenging settled law. Should lawyers pursue what they believe to be morally right in light of possible career suicide and tremendous mental drainage in order to push for change in unjust laws? The framers of the Constitution allowed an avenue where laws found to be unjust could be overturned and modified when found necessary, but to change these laws, well-settled law must be challenged. Well-settled law is a law that the court has not decided to overturn yet, or a law that a future court is unlikely to overrule. Settled law or well-settled law has a few different types of definitions, but all come to a similar consensus. Those on the front line of the justice system are left to fight these laws, lawyers. But to make this process hard, lawyers aren't allowed to challenge settled law without providing a justified argument of good faith. However, good faith can be opinionated, leaving some to believe arguments to be invalid. U.S. history has shown us time and time again that a good faith claim is not recognized universally. Examples in history include the crack versus cocaine disparity, Brown v. Board of Education, Miranda v. Arizona, and the revision of the 14th Amendment. Each of these landmark cases and revisions were argued for many years in the courts due to differences in opinions and perceptions of the time. What if the individuals you are trying to argue your point to do not believe there is a basis for modification or that there is any unjust present? The individual may be seen to be breaking ethical obligations if their argument doesn't meet the requirements. Even if you have a valid case for going against well-settled law, you may be shamed and criticized. If the law needs to be changed or reinterpreted, the only way to accomplish that goal is to argue against the existing law, even if individuals at that time do not believe there is a reasonable good faith. So what is the right thing to do? If the individual in the position of power to argue for modification chooses not to, unjust policies and laws will continue to destroy lives. When facing the possibility of career suicide, loss of professional respect, and potential loss of employment, many choose to stay silent and let someone else fight the battle. Lawyers and activists who do choose to fight this may be put in a position to argue over and over for years, maybe even decades, before someone decides that they might be onto something. As we saw earlier with the court cases mentioned, that standing up against the system is necessary to make much needed change, but can take many years and strength from individuals who choose to continue fighting. We know choosing to go up against a system that may deem your argument unjustified may ruin your career and put stressors on the individual's mental health. But what if you know with every nerve in your body the law was wrong? Do you follow precedent like so many before you have done and will continue to do? Or do you go up against the system and potentially commit career suicide and be ridiculed in the process, but aim to make a change when you can? This can be a very hard decision, but we can see why it is so important. This process is a very strenuous process for many. I have compiled a few possible options to make this process easier for some to pursue. Implement encouragement. Law schools, institutions, and employers should encourage lawyers to know the well-settled law and recognize opportunities for improvement or needed change. Lawyers need to be prepared and willing to go up against higher-ups and those in power to make a change. Encouragement and motivation will create an environment where people can feel like they have the power to speak out and that they can speak out and speak up for justice. National encouragement programs. Programs for widespread encouragement and empowerment to not stay silent that all attorneys, defense, and prosecutors alike have to attend annually that expresses the importance of not staying silent, while also teaching how to argue against settled law with adequate evidence properly. These programs could also provide support for any backlash that the individual may be faced with by their employer to prevent loss of employment or discrimination. If there was a move of nationwide support and acceptance, this could leave many to feel less stress over potential loss of employment and negative perceptions of them, defining future career possibilities. Continuing education in ethics and constitutional law. Attorneys are already required to do a predetermined amount of continuing education hours annually. A certain number of these hours should be designated to ethics and constitutional law. Reviewing constitutional law would ensure that most are up to date with up-to-date revised laws. This may also draw attention to laws that may need revision. Ethics hours would ensure that all individuals were aware of ethical dilemmas they are faced with and how to best navigate them. Doing this will remind individuals of their obligations to protect the rights of others and to ensure those rights aren't being infringed on. Without individuals throughout history being willing to pursue an issue of which they believe needed change, despite possible professional suicide in the short term, the United States would be unjust and an unruly society. Over generations, people change, ideals change, and expectations change. As a changing society, laws should surely change with the times as well to fit the needs and ideals of the people. But they should also correct past mistakes. This is why it is immensely important for individuals to see the light at the end of the tunnel and to know that they are supported and not ridiculed for trying to make a positive change. Thank you for watching.